In this next topic, we look at Islamic legal procedure. How are cases actually resolved? You know, legal procedure is important. It's important in every legal system. And to understand legal procedure and why it's so important, we need to really go back and think about the nature of the law. You know, for every law, there are two aspects to that law. There is a right under the law, and there is a remedy, which is a means to enforce the law. So every law has within it both a right and a remedy. And you could say that the remedy is just as important as the right, because the remedy, the availability of a remedy, is what gives the law meaning. It's not simply a command to do or not do something, but it's also the ability to recover against the person or thing or entity that does or does not act in compliance with the law. So the remedy requires a means of enforcing the laws. And we enforce the law through legal procedure, extensive legal procedures. We do that in the West, we do that in civil law and in the common law, and it's the same in Islamic law. Now, there is something interesting about legal procedure, though. Legal procedure can determine legal substance, meaning how we enforce a law can often lead to substantive legal decisions about how we craft a particular contract or document or agreement before a dispute ever arises. For instance, in the West, and certainly in the United States, there is a great preference given to written documents. A contractual writing is often cited as the best evidence of what the parties intended to cover in their agreement. And in fact, we have what's called the parole evidence rule. And the parole evidence rule says that if there is a writing, then everything else should be excluded, meaning the testimony of the parties as to what was in their heads when they signed the agreement is immaterial. Instead, the only important feature is, what does the writing say? Now, because legal procedure, our legal procedural rules reflect the importance of the writing, that means that when we prepare contracts, we as attorneys are always very careful to put everything into the contract that we can think of. If you've wondered why your iTunes license agreement consists of 32 different screens of text, the idea is that lawyers have looked at that and they want to put every potential source of conflict into that document, because the writing will take the place of what you thought or I thought or anyone thought when they executed that agreement. So the law can evolve in light of the procedure that is used to enforce the law. So that's why it's important that we look at legal procedure in Islamic courts, because legal procedure in Sharia courts differs from that in Western courts. How so? Well, first of all, in Islamic courts, the legal professional, the lawyer, plays a much more restricted role. Courts in Islamic legal systems traditionally do not rely on lawyers as intermediaries between the client, the litigant, and the court. In Western systems, and especially here in the United States, the lawyer speaks for the litigant. The lawyer, what the lawyer says is the litigant's own official position on an issue. Well, in Islamic courts, the lawyer plays a much more restricted role. Instead, in Islamic courts, the courts want to hear from the actual parties themselves, from the plaintiff and from the defendant. So in most Islamic courts, lawyers are not even present. The parties themselves are there. For an analogy, you could look at small claims courts here in the United States, which have a much smaller role for lawyers. Well, in Islamic courts, even on cases involving high amounts of money or many important things at stake, the court doesn't want to hear from lawyers, they want to hear from the litigants themselves. Now, there is no jury system in Islamic courts. Instead, trials are conducted solely by the judge. The judge will hear the evidence, the judge will weigh the testimony, and the judge will issue a decision. The idea that there's going to be some third-party fact finder, which is what a jury is in the American system, does not exist in Islamic courts. In Islamic courts, there's no pre-trial discovery system. If you remember from your introductory legal studies course, you probably studied discovery, how discovery works. In the West, and especially here in the United States, the parties will routinely engage in a year-long process of exchanging information that could come about as a result of a series of questions, what we call interrogatories in the law, or it could be depositions in which we actually take sworn testimony from witnesses and from the parties themselves. There's a lengthy process that goes on before a case ever reaches trial. And this pre-trial discovery process is meant to narrow the issues before trial to only the important issues. Well, in an Islamic court, there is no pre-trial discovery, meaning when you go to court, you don't know what the other side is going to present as evidence, and they don't know what you will present as evidence. Now, furthermore, in an Islamic court, there is no cross-examination of a witness. If you've seen any legal TV show or movie, you know that cross-examination, examination of the opposing party's witness, is fundamental to how we resolve cases. It's how we handle getting to the truth of cases. Well, and in fact, both parties have a right, a guaranteed right, to examine, to question the other party's witnesses, and they have to do so under oath. Well, there's no cross-examination of witnesses in an Islamic court. Instead, each side presents its case. They tell the story of what their side of the dispute is, and the judge can determine on his own the credibility of each witness. And that's part of what the judge is meant to do. So no cross-examination of witnesses. Furthermore, under Islamic law, the judge's verdict do not set a binding precedent. In every case brought in an Islamic court, there is no precedent based on what other courts have said as to this issue. So in an Islamic court, the parties are not able to rely on pre-existing cases as determinative of the case at hand. The rules of evidence in Islamic courts also differ dramatically from in Western courts and civil or common law systems. I said that in the West, we place great emphasis on written documents. The written document is the important document. What is in people's heads does not matter. because it's all going to be encompassed in the writing. Well, in Islamic systems, the writing is of relatively little importance. Instead, the court wants to hear of the mindset of the parties in a dispute. So in a typical contract dispute, the court is going to be concerned with what did the parties think? What were the parties' belief in what the contract meant? The writing is of relatively little value. And instead, the sworn testimony, the testimony under oath, is what's more important. Now, I mentioned that legal procedure can govern legal substance, and this is a very good illustration of that. In the United States, when attorneys are drafting contracts, when parties are negotiating agreements, they try and put as much as they can into the writing. Well, in an Islamic system, it would be to your benefit to have as little as possible in writing, so that if there is a dispute, you can establish your case by oral testimony, saying what you believed the contract meant or contained within it. Now, these oaths, I said we have those in the West as well, but in the Islamic system, the oath has an evidentiary value of its own, meaning that if a party is willing to swear an oath to his testimony, then that oath itself has evidentiary value, meaning that testimony has greater weight simply because it was executed under oath. And oaths are taken very seriously, that if the litigant refuses to swear an oath to a statement, then in fact it is grounds to have automatic win for the other side based on that. Refusing to take an oath can result in a verdict for the other side. Now, the final thing I want to say about Sharia law and the issues with Sharia law is that Sharia law is fixed. It is fixed. Because it's based on the notion that God expressed the law in the Quran, then the law cannot change. So Sharia judges and scholars cannot change the law, they cannot modify the law or extend the law. Instead, they are bound by the law as it existed in the 1500s. And the only change to that is to look at analogy. So what happens is that Sharia law sometimes is at odds with the modern world, because Sharia law cannot be updated, it cannot be changed, it's not flexible to adapt. Instead, Sharia law is based on a fixed idea of truth, which can never be changed. The final topic I want to cover in this lecture is a case, a discussion of a case that's found in your textbook, and that's Kaki versus Hashim. Now, this case was interesting in that it pitted Sharia law against the realities of the modern financial world. This case involved the collection of interest by an Islamic bank. And in Islamic law, the collection of interest is against Islamic law. The reasoning behind this is that money should not be used to make money, that there is an ethical means of making money, and that's by doing work, by investing, by sharing the load. It is not morally right to use money to make money. Now, this position, you may think, well, that seems very odd, but in fact, in the United States, we have a related concept. There's a concept called usury, U-S-U-R-Y, and virtually every state has a law against usury. Now, what's usury? Usury is excessive interest. interest that is beyond a certain amount, meaning one can collect interest, but not too much interest. And the prohibition on usury, again, goes back to ethical codes and ethical considerations, meaning even if the parties agree to a high rate of interest, the law says you should not be permitted to reach that agreement. So we kind of have the same idea, the same concept in the West in terms of prohibitions against interest. Well, in the Kaki case, the court was faced with how do modern financial systems work, and they work because of interest. But the court says the collection of interest violates Islamic law, and that can't be changed regardless of the modern financial system. Now, it was a very long opinion that they've summarized in your text, but in the opinion, the court actually says, look, there are ways to accommodate the same principles as would be involved in the loaning money and getting back more. One of the easiest way to do that would be some sort of joint venture agreement in which the bank and the borrower enter into a partnership, and the proceeds, the profit from that partnership, could go back to the bank. And that doesn't violate the law against interest because the bank shared the risk in terms of what it got as a reward. So there were alternatives to the collection of interest, which would enable a bank to accomplish the same thing. Joint ventures, partnerships, or creating some other way in which the bank was not simply using money to make money. So that's an example of how Sharia law can sometimes be at odds with the modern world.